Magandang Biyernes po sa inyo, aking mga kausapan. Please like, share, subscribe, and press the ting-ting bell button para ma-notify kayo sa aking susunod na vlog. Ito ang iyong abang lingkod, Usapang Batas with Attorney I. I swear to tell the truth, the whole truth, and nothing but the truth. Ito ang ating laging marinig sa korte pag ikaw ay witness sa kaso at nasa witness stand. Pagkatapos dyan natin malaman kung ang testimonya ng tao ay katotohanan o perjury. Makikita sa Article 183, false testimony in other cases and perjury in solemn affirmation ng Revised Penal Code o Kodigo Penal ng Pilipinas. Sabi ng Article 183, ang kaparusahan ng Aristo Mayor sa kanyang pinakamataas na panahon hanggang prison correctional sa kanyang minimum period ay papataw sa kahit sinong tao na knowingly make untruthful statements and not being included in the provision of the next preceding articles. Dito tayo sa province of Eastern Samar, Binasangay, Marine Eco Park and Resort, Balangkayan, Eastern Samar. Shall testify under oath or make an affidavit upon any material matter before a competent person authorized to administer an oath in cases in which the law so requires. Ang bawat krimen ayon sa ating Revised Penal Code ay may elements. Attorney I, ano naman ang elements ng perjury? Ang elements ng perjury ayon sa Article 183 of the Revised Penal Code ay ang mga sumusunod. Ang first element ay false statement upon a material matter. Ibig sabihin, hindi lahat ng kasinungalingan ay perjury dahil kailangan ng offender ay naggawa ng kasulatan at iyon ay under oath at B, upon any material matter. Klaruhin natin ang sabi ng Revised Penal Code. Further, kailangan na ang kasinungalingan ay sa material matter. Ano ang material matter? Ang material matter has been defined as the main fact which is the subject of the inquiry or any fact or circumstances which tends to prove the fact or any fact or circumstance which tends to corroborate or strengthen the testimony relative to the subject of the inquiry or which is legitimately affects the credit of any witness who testifies. Yan ang sabi ng kaso ng Masangkay versus People, GR number 16443, 18 June 2010. Ang ehemplo sa false statement ay tungkol sa address ng isang tao. Yan ay nakasaad sa kanyang affidavit tungkol sa banggaan ng sasakyan at ito ay sinumiti sa insurer at ang banggaan ay nangyari sa ibang lugar. Iyang kasinungalingang yan ay napapaloob sa dokumento as a requirement as to form, pero di legal na requirements. Yung kasinungalingan na yan sa dokumento, while deplorable, is not actionable as perjury under the Revised Penal Code because the address of a person under such circumstances is neither the main subject of the inquiry or a main fact. The statement or affidavit was made before a competent officer authorized to receive and administer oaths. Yan ang second element ng perjury. Before a person competent to administer oath. At sa pangalawang element, ang sinasabi ng batas ay dapat yung sworn statement o affidavit na nagsasaad ng kasinungalingan ay ginawa sa harap ng taong competent to administer oaths. Ang notary publiko ay ang pinakasaktong ehemplo ng taong otorisado ng batas na mag-administer ng oaths. Mayroon ding ibang public officers na binigyan ng kapangyarihan ng ating batas na kakayahan o kapangyarihan na mag-administer ng oath. Halimbawa, ang ilang miyembro ng ating kapulisan who in certain capacities can subscribe to a sworn statement, thereby fulfilling the legal requisite. C. In the statement or affidavit, the accused made a willful and deliberate assertion of a falsehood. Yan ang third element ng perjury, willful or deliberate. Para makasuhan ang taong nagsinungaling ng perjury, kailangan naroon ang third element na ang taong nagsisinungaling dapat ginawa niya iyang false statement willfully or deliberately. The term willfully has been defined as intentionally with evil intent and legal malice, with consciousness that the alleged perjury statement is false, with the intent that it should be received as a statement of what was true in fact. If this is equivalent to knowingly, deliberately implies meditated as distinguished from inadvertent acts. Therefore, to satisfy this requisite, it must appear that the accused knows his statement to be false or is consciously ignorant of its truth. That's the case of Morford III et al. Versus Salvatierra et al. GR number 168301, 5 March 2007. In relation to the third element of perjury, quite clearly, honest mistakes is factual statements made under oath are forgivable. However, good faith must be proven that the mistake was not made intentionally or that the person who executed the affidavit with the falsity did so through oversight or inadvertence. D. The sworn statement containing the falsity is required by law or for a legal purpose. Luis Reyes B. The Revised Penal Code, Book 2, page 272, 1998 edition. The fourth element of perjury required for a legal purpose. The final and arguably most significant element for a willful assertion of falsehood to be punishable as perjury is that the affidavit or sworn statement must be required by law or for a legal purpose. Not all affidavits, even if containing absolute falsehood, can subject a person to the crime of perjury. The Revised Penal Code requires that the sworn statement or affidavit must be executed pursuant to a legal requirement. Thus, in our previous example about the affidavit concerning a vehicular collision containing a false address, if there is particular law that requires the submission of an affidavit prior to making an insurance claim, and more importantly, a particular legal requirement to disclose such address in the affidavit or sworn statement, then the lie becomes a material matter. More importantly, the person that executed such false affidavit may arguably be liable for the crime of perjury because the affidavit is submitted as part of the legal requirement or in compliance with the law. Andito ko ngayon sa Sir Juan Island sa province of Eastern Samar. Ang tanong, Attorney I, ano naman ang kaparusahan pag ikaw ay napasahan ng perjury? Ang sagot ay ang Republic Act number 11594 na naging patas noong October 29, 2021, amended Article 183 of RA 3815 or the Revised Penal Code, which penalizes perjury. Under RA 11594, persons who would commit perjury face a higher penalty of prison mayor in its minimum period to prison mayor in its medium period from 6 years and 1 day to 10 years of imprisonment. So ngayon, nadagdagan na hanggang 10 taon na ang pagkakulong pag ikaw ay nag-commit ng kasong perjury. The penalty of prison mayor in its minimum period to prison mayor in its medium period shall be imposed upon any person who, knowingly making untruthful statements and not being included in the provisions of the next preceding articles, shall testify under oath or make an affidavit upon any material matter before a competent person authorized to administer oaths in cases in which the law so requires under Republic Act 11594. Previously, persons guilty of perjury were only sentenced to arresto mayor in its maximum period to prison correctional in its minimum period, or from 4 months and 1 day to 2 years and 4 months of imprisonment. Ngayon mga kausapan, medyo umabot na ng 10 years ang kaparusahan ng kasong perjury. For public officers or employees who would commit perjury, Republic Act 11594 states that the penalty of imprisonment will be imposed in its maximum period along with a fine of 1 million as well as the perpetual disqualification from holding any appointed or elected position in government. So medyo mahirap-hirap na ito ngayon. Pwede kang ma-disqualify sa appointed position or even hindi ka na pwedeng tumakbo or elected position in government. If the person responsible for the commission of this felony is a public officer or employee, the penalty shall be imposed in its maximum period, provided finally that the offender shall also suffer a fine not to exceed 1 billion pesos and perpetual absolute disqualification from holding any appointed or elected position in the government or in any agency, entity, or instrumentality. Republic Act 11594 also amended Article 184 of the revised penal code to include the willingness of a witness to provide false testimony in any judicial or official proceeding. Any person who shall willfully and knowingly offer in evidence a false witness or testimony in any judicial official proceeding shall be punished as guilty of false testimony and shall suffer the respective penalties provided in this section. Yan ang sinasabi ng bagong batas. If any provision of Republic Act 11594 is declared unconstitutional, the same shall not affect the validity and effectivity of the warrant provisions thereof. All laws, rules, and regulations that may be inconsistent with the provisions of RA 11594 are hereby repealed or amended accordingly. Bagong batas na ito ay a consolidation of the Senate Bill number 1354 and House Bill number 8268 passed by the Senate and House of the Representatives on August 23, 2021 and August 13, 2021. Salamat sa inyong pagsubaybay mula sa karagatan ng province of Western Samar. Ito ang iyong abang lingkod, Attorney I, sa Pagbatas with Attorney I.